The next matter to come before the court this morning is State of Ohio versus Alex Garcia. Ms. Corrigan, the state has waived oral argument, so there'll be no need to reserve time for rebuttal. We've read the briefs and we are ready to see when you are.
Yes, thank you, Your Honor. May it please the court, good morning. My name is Jacqueline Corrigan and I represent the appellant in this matter, Mr. Alex Garcia. And as I did 2 weeks ago, I must again apologize to the court for the state of my voice, which is not quite adequate, but we'll soldier on. Mr. Garcia is challenging his burglary convictions and saying that they should be reversed for 2 reasons stemming from the admission of expert testimony about the location of his cell phone at the time of all 4 burglaries. The first reason is that the introduction of unauthenticated cell phone records upon which the expert testimony was based violated Mr. Garcia's rights under the Confrontation Clause. And then second, that because the cell phone records were not authenticated, there was no valid basis for the expert's testimony under Ohio's Rules of Evidence. Regarding the Confrontation Clause, there is authority from the Ohio Supreme Court, from State v. Hood, that says that unless cell phone records of this type are authenticated, pursuant to Evidence Rule 901, and unless there's also a foundation laid, pursuant to Evidence Rule 8036, that's to show that the cell phone records are also business records under the evidence rule, that the cell phone records themselves are considered testimonial in nature. And under Crawford v. Washington, we know that testimonial hearsay statements are only permissible under the Confrontation Clause when first the witness is unavailable, which they would be, I would concede, with cell phone records because they're kept basically by a machine. And also that the defendant has had a prior opportunity to cross-examine the witness or the hearsay, which would be impossible in cases like this because, the keeper of the record is actually, the compiler of the record is a machine, and it would be difficult, if not impossible, to do prior cross-examination. So, for records of this type, this is why they have to be authenticated, and they also have to be proven or shown to be business records. Because business records, as we know, are not necessarily, they're not considered testimonial in nature, by the nature of what they are. But in this case, we have the testimony of an expert who is a radio frequency engineer for the cell phone company at issue. He's not the person who actually deals with the compilation of people's call records or the billing or anything of that nature. He's just the person who deals with designing the network, managing the efficiency of the network, and dealing with the cell phone towers. So he was an expert to say where within the range of the cell phone tower pickup a particular call originated. But he was asked by police to look at a list of calls and their origination points that police had subpoenaed from the custodian of records, but without bringing in the custodian of records for those cell phone calls to say, yes, these are the calls, this is an accurate record, these are the records that we keep contemporaneous with the calls coming in, that we're familiar with how they're kept, we can vouch for their authenticity and their veracity, and that these are records that are kept in the regular course of business. The witness that we have instead, Mr. Carlisle, the tower expert, was not able to say that he was familiar with any of that, of how the records are kept, how they're generated, and so he was unable to authenticate the root data from which he was testifying. And so because he could not lay the foundation either for the record's authenticity or for there being actual business records that are not by their nature testimonial, then the introduction of those records and his testimony based on them were actually, or should have been excluded from trial and were inadmissible. And because they were brought in, they violated the confrontation clause in my client's case. As to the basis for Mr. Carlisle's testimony, they also ran afoul of Evidence Rule 703, which specifies that the information that must underlie an expert's testimony in Ohio has to be facts or data that is either perceived by the expert firsthand or admitted into evidence. And again, I submit that the evidence was inadmissible, and so it was an abuse of discretion to allow the expert testimony. And I sense that there are some questions. Judge Schaefer.
Well, it sounds to me like you're just suggesting that the machine is the witness, or the computer programmer who designed the program should be the witness.
Well, I'm just acknowledging that it's a machine that keeps the record and is, you know.
Then if the machine is keeping records in the ordinary course of business, because that's the records that it's keeping, is the records of the business, these are the things that transpire that the program was written to produce, I'm having a hard time understanding why a person could.
Well, actually, there have been some other districts that have had testimony that have actually solved the problem. And where, for instance, if the custodian of the billing records at Sprint had come in and said, this is how the machine keeps the records, and I know this because I work with the machine, and I'm the one who has to deal with the records that the machine spits out. That would be an appropriate way to authenticate the records and to show that they were business records under the rule.
And there was no testimony by this witness in that regard at all? I mean, there's something in some flavor of up until 90 days, he's familiar with retrieving documents, but there was no question and answer regarding that?
He did testify that he has access to the records for 90 days, but he could not vouch for how they're generated or how they're kept after that either. And the record in this case is that he didn't receive these records even from within his own company. He received them on a CD directly from police who had subpoenaed them from his company, but the custodian of records who had responded to the subpoena was not present to testify that yes, what's on the CD is indeed what we turned over to the police officers, and that they hadn't been altered, that they were verifiable and they were accurate.
And I understand that there's a sign of error regarding trying these cases together, but could you speak to whether or not, well, if this is error with respect to the cell phone records, is it reversible error as it relates to all of the counts and convictions in the complaint, or does it more specifically relate to one of those counts?
It relates to the 4 burglary counts. It doesn't relate to the receiving stolen property count that was in the separate indictment that was charged with, or tried with this case.
And with respect to those burglary counts, is it related to one specific count more than the others, or?
No, Your Honor, it relates to all 4 because Mr. Carlisle testified as to the, where within the range of a tower or which sector of a cell phone tower my client's cell phone connected with the system on each of those 4 dates when there was a burglary that was charged and tried in this case. So it relates to all 4 of the burglary counts, but not the receiving stolen property, which, as we know, had separate proof. And I would submit also that if you do find this error, it's not harmless error, because as we know, for constitutional claims like this, in order to be harmless error, it would be harmless only if the other evidence in the case were overwhelmingly would establish my client's guilt without the testimony of Mr. Carlisle. And the other evidence in this case would not even put my client in the vicinity of even one of the burglaries in question. There was testimony from a Mr. Wilson who puts my client at a different location on a different day actually 2 different locations on 2 different days, one regarding a burglary and one regarding some use of a credit card. But in both cases, his testimony related to a location that was in some, I think in one case it was over 2 miles from one of the burglary locations, and also was on a different day. And with the cell phone, it was over a mile away from where, or not the cell phone, but the credit card, it was over a mile from where the actual stolen credit card was used. So it's not evidence that my client was guilty of any of the burglaries for which he was actually tried. So, and also in addition, the mere fact that there were items that were stolen in these 4 burglaries that police found at my client's house and in a vehicle parked outside his house that wasn't his vehicle but was nevertheless in his driveway. The mere fact that he had some of the items stolen in these burglaries does not mean that he actually was the person who stole them. That doesn't mean that he was there. His testimony at trial was that he had purchased those items either at stores or from Mr. Wilson and his brother. So the mere fact that, and there is case law that I mentioned in the brief, the mere fact that somebody has some stolen items in their possession does not mean that they're the actual person who stole them.
Does one of the Mr. Wilson individuals testify to the fact that Mr. Garcia was involved in the burglaries?
He did, but when he described where the burglary that he allegedly witnessed took place, that burglary took place somewhere around Manchester Road, which is about 2.5 miles west of the Coventry Township burglaries that were charged and tried in this case. And Manchester Road isn't even in the vicinity of the Copley Township burglaries that took place. Manchester Road, if one's familiar with the Portage Lakes, it's completely different sides of the Portage Lakes from Coventry. The Schwartz Road burglaries to Manchester Road. So Mr. Wilson testified, yeah, I saw him burglarize a place, but it's not these places. And it's not the same day even that any of the burglaries took place. And Your Honors, I see that even though my 15 minutes is not quite up, otherwise, if there are no further questions from the court, I would rest on my briefs and respectfully ask you to reverse my client's conviction.
Thank you, counsel. Seeing none, court will take the matter under advisement, issue a written decision, and permit it to be mailed to both sides as well as posted on the Supreme Court website. I hope you are feeling better soon, counsel.